Turning to three studies of the legal field that have involved Bourdieu's theoretical tools, Ment and Turner, 2006, conducted an ethnographic study by observing and interviewing law students attending a weekly social function called the Coffee House at a Canadian law school. The Coffee House, sponsored by law firms, provided finger food and alcohol to the students and ostensibly offered students an opportunity to network with lawyers from law firms. The researchers mapped the movements of the students and the lawyers at the weekly functions and conducted semi-structured interviews with the participants. The Coffee House was a social microcosm situated within the subfield of legal education, between the academy and the profession. The students' dispositions inclined them to prize the position of student and member of the legal academy and disavow any interest in law firm branding, networking, or the social attributes of a practicing professional. However, the Coffee House was also a place to rehearse the deployment of the tools of social capital. The students could observe how the lawyers' clothing and attitudes contributed to their professional identity and set them apart as a social group. The Coffee House experience encouraged students to feel the difference between their being and their becoming. Despite initial resistance, over time, student identity, individually and as a body, was transformed physically, subconsciously, and imperceptibly to entrench and internalize the occupational status hierarchy of the legal profession. Jewell, 2008, reviewed the literature and the documentary artifacts to study the issue of class in the field of legal education in the USA. She reviewed the ranking and evaluation system used in legal education and investigated how law schools reproduce the image of the legal profession as upper-class structure and the way in which these cultural expectations affected students. Of particular interest to me was her comparison of career trajectories between those who attended vocationally oriented night schools and those who attended top-tier law schools, and the implications that education might have for student attitudes towards professional skills training. Jewell concluded that in the USA, the structure of the legal education system contributed to inequalities within the legal profession and reinforced the representation of the legal profession as an upper-class profession. Hay and Hagen, 1998, studied gender stratification in the Canadian law firms. They investigated factors that might explain why female lawyers were chosen less often for partnership in law firms, and whether female lawyers were judged by standards that were different to those for male lawyers. They used field and habitus as a theoretical framework for an analysis involving standard descriptive statistics and factor analysis. They measured items of social and cultural capital, including family, occupation background, ethnic religious group membership, and legal education, together with law firm size, prestige, practice specializations, frequency of out-of-work hours professional activity, membership of professional associations, and client-based characteristics. They measured dispositional factors by asking respondents to rate the importance of certain achievements, such as achieving seniority, appointment to the judiciary, leadership in legal education or law reform. They concluded that law firms may act to reproduce a practice culture through a partnership selection process that requires women lawyers to model themselves on an exaggerated image of those who have traditionally been considered suitable candidates for partnership. This may be a cultural pattern with significant structural consequences, giving priority to everyday practice-oriented concerns over broader reforms to the legal profession. In my opinion, Kay and Hagen's study was comprehensive and rigorous and is a useful model for the design of this type of research. One observation that especially interests me is the value of graduate lawyers' academic capital depreciating during their induction into the law firm. Does something similar happen to whatever capital attaches to graduate lawyers' practical legal training? My current research interest concerns the scholarship of teaching and practical legal training, and in particular, how lawyers acting as trainers engage with a scholarship of teaching. I am interested in what is the position of the field of PLT in Australia in relation to other legal fields and the field of law and the field of power. Are the objective structures of the relations between agents vying for legitimate authority in the field of PLT. What is the habitus of PLT teachers, their system of dispositions, and the trajectory and potential actualisation of those dispositions? What particular structure of habitus is in play compared to other possible habitus structures? How can we tell when that habitus has changed, varied, or remained the same? How does the habitus of PLT teachers affect their motivation and capability to pursue a scholarship of teaching? How do individual and organisational agents' symbolic representations of PLT support the pursuit of a scholarship of teaching? How do organisational allocations of resources support pursuit of a scholarship of teaching? What are the strategies and tactics of agents seeking to pursue a scholarship of teaching in PLT? So that's it from me. I hope that you found this presentation on Bourdieu and the legal field interesting. I'd like to add that I'm especially indebted to my lecturers at Deakin University, and also if you're interested to know about the basic of Bourdieu's theoretical tools, I recommend that you look up Carrie Alexander's presentation on YouTube.